starting with case number 17CA0083M, Mark Overholt et al. Versus Montville Township Zoning Inspector. Each party will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes if you would like to for rebuttal. Just make sure you let me know before you get started how much time you would like for rebuttal. The arguments are recorded and are posted on the YouTube channel of the court, so please remain at the podium and keep your voice up. All of us have read the briefs and we are ready to proceed if you are.
Good morning, Your Honors. May it please the court, counsel. My name is Benjamin Ochner. I'm with Burns, Ochner, and Greenberger, and we represent the appellants, Mark and Cheryl Overholt and Tiger General. And on their behalf, we urge you to reverse the common pleas court decision in this 2506 administrative appeal. I would like to reserve 5 minutes of my time for rebuttal.
Thank you.
We have two assignments of error. One is an almost purely legal issue, and that assignment of error basically is that the Common Pleas Court and the Board of Zoning Appeals both erred by applying to conduct in 2012 a zoning provision that had been repealed at least 6 years earlier. And the application in 2012, I should be a little more clear, related to conduct alleged to have occurred in 2012. The other assignment of error is a fact-intensive matter involving whether a collection of motorcycles that was permitted by a March 2002 amendment to Mr. and Mrs. Overholt's conditional zoning certificate had somehow become a junkyard. Now, I want to be clear about that second assignment and its fact-intensive quality. We are relying, as we have throughout this proceeding, we're relying on a couple of things. One, what is it that is out at the property? Two, what is it that the township zoning inspector maintained was a junkyard? And of course, three, what does the zoning resolution provide? And on both assignments of error, we think that the answers are clear, and contrary to what the BZA concluded and what the Common Pleas Court concluded. The first issue relates to a provision in the Montville Township Zoning Resolution, Section 307E, which prohibited the outdoor storage of inoperable vehicles. Now, that provision shows up on, or there's reference to Section 307E on various iterations or versions of the conditional zoning certificate that was issued to the Overholts. It was placed on there, and then in a subsequent conditional zoning certificate, the reference to Section 307E was removed. That was an interesting discussion that has really no bearing at this point. What does have bearing at this point is that by 2012, in fact by 2006, in fact as early as 2004, the Section 307E no longer existed. It disappeared from the zoning resolution and therefore ceased to be of any effect. Let me very briefly describe the circumstance under which we determined that the conduct, in this case, the Overholt's conduct that was the subject of this alleged violation, occurred in 2012. The notice of violations is this very onerous but ambiguous notice of 13 different violations that doesn't specify any, there are no facts specified, there are no dates specified, there are no specific provisions of the zoning resolution included in the notice, and there are no specific provisions of the conditional zoning certificate included in the notice of violation. And so when we started the hearing, and this hearing consumed 7 different hearings that began in February of 2013, and the last was in July of 2013, what we did was, I had to ask the zoning inspector, what are the facts on which you base violation number 1? When did they occur? What's the basis for your saying that that occurred? What provision of the zoning code or zoning resolution was violated? What provision of the conditional zoning certificate was violated? And we went through that pretty much with each of the 13 notices of violation. And when it came to the outdoor storage of motor vehicles, inoperable motor vehicles, the zoning inspector testified that the conduct that was the subject of that allegation occurred in 2012. So it's a simple legal premise, legal proposition. And if you cannot be held liable for conduct that occurred in 2012 that allegedly violated a statute or an ordinance or a provision of the zoning resolution that was repealed 6 to 8 years earlier. Now, with respect to the more fact-intensive inquiry, the junkyard, this comes down to, like I said earlier, really a handful of facts. First is, what is a junkyard? There is a definition in the Montville Township zoning resolution of junkyard. And the other question is, what is it on the zoning, the Overholt's property that is supposed to be a junkyard? What we asked the zoning inspector, and what she was clear and consistent about throughout the hearing, was whether there were some engines, there were some tires, there were some gas tanks. Are those part of the junkyard? No. She said no. They're part of the ongoing business. I don't consider them to be the junkyard. What is the junkyard? The junkyard is the collection of motorcycles, a collection which was described various times over the years as being very neat and orderly. But on multiple occasions, she said the junkyard is the collection of motorcycles. From whence did that collection of motorcycles come? Well, it started back in 1997 or so, during the minutes of a BZA 1997 meeting are in the record. Mr. Overholt stated that there was a motorcycle business on the property that he wanted to get approval for. Didn't happen in 1997, but in 2002 it did. And in the 2002 minutes, that's the meeting at which conditional zoning certificate number 9 was approved. The minutes make it clear what the motorcycle collection and motorcycle business are, and they make clear that the BZA fully understood what the business was. After March of 2002, the motorcycle collection expanded. Now, when the BZA approved the motorcycle business in 2002, it did not impose any restrictions other than those which may have been applicable by way of perhaps side yards and setbacks. It did not impose any limitation on the number of motorcycles or on the amount of area of the property that could be used for the motorcycles.
It did require them to be licensed or titled or registered, correct?
Well, what it said is that it called for the sale of newer used vehicles that would be currently licensed or titled. So the sale, at the time that they were sold, they had to be currently licensed and titled. As far as the that's the language of the zoning of the certificate itself, and the sales and other vehicles that would be currently licensed or titled, that would be.
6 minutes now. So you have about a minute before you start eating into your rebuttal, unless you want to use that.
No, I'm at 45 seconds here.
Okay.
Thank you. And I'm happy to answer any other questions, but to tie up this part of my argument, Your Honor is correct. It talks about licensed title. Our view is that according to the language of the zoning certificate itself, that would be the sales when those vehicles are sold. Now, I'll just add this. From a land use standpoint, it doesn't matter in terms of the impact on the neighboring properties and on the community in general. It doesn't matter if there is a license or a title. What matters is what's going on the land itself. So, our view is that according to the specific language of the conditional itself, when those vehicles were sold, they had to be licensed or titled. There's no evidence in the record at all that any vehicles that were being sold from the property were not licensed or titled.
What about parts?
What about parts? No.
I don't mean to eat up all your time.
No, it's a fair question. And on parts, our understanding is, and I think that the zoning inspector agreed with this, that the minutes of the March 2002 BZA meeting, there was an exchange between Mr. Overholt and Bill Thorne, the county prosecutor who was representing the township at the time. And the exchange was basically Mr. Overholt said, what about parts? Are they covered? And Mr. Thorne answered the question. I don't remember the exact language, but I did ask the zoning inspector if she understood that to mean that parts were covered, and her response was yes. So
Are those minutes part of the record?
they are.
All right, thank you. I've got you at 3 minutes and 50 seconds left.
Thank you.
Good morning.
Good morning. Get myself started here. My name is Katerina Devani, and I am an attorney representing Montville Township on this matter. I'd like to start by saying Mr. Ochner stated that there were two main errors. The one was in applying to conduct 2012 on the zoning provision regarding the outdoor storage. And on this issue, the township has been very clear. Section 307E at that time was an overall section that applied to every property within the district. Whether it was part of the conditional or not is irrelevant, because there is something in all conditionals in Montville Township that state that you do have to comply with the township zoning for the area.
When was it repealed?
I am uncertain of when it was repealed. It was replaced, however, with a section 431.H.
When was that?
Again, I'm sorry, I don't have that with me.
All right,
It is in the record, however.
and then we'll find it.
Thank you. When it was removed, it still really didn't have any kind of applicability to the property, because the property itself, no junkyards were permitted in that district. They have never been permitted since zoning was enacted in 1950. This particular district, with the current zoning and the previous zoning that was on it before, never allowed junkyards. Now, the replacement section, 430.1.H, does allow some outdoor storage, but it's a may in the language, which means that they would have to come before the board and ask for permission to have the outdoor storage, and they have never done so. Now, if they were to come now, of course, that would be something that could be heard as well. But up until this date, they have never requested the ability to have the outdoor storage on this particular property. As for the junkyard itself, The township does have a definition for junkyard. And again, it's very clear. It's any use of more than 25 square feet of any land, building, or structure, and I'll go on to ... where waste, discarded, or salvaged materials such as scrap metals, used building materials, used lumber, used glass, etc., are stored. This particular collection of motorcycles is termed by the appellants themselves in their business materials on their website as their salvage yard. It is full of salvaged materials, salvaged metals, salvaged glass, salvaged bits and pieces of motorcycles. That is not, it fits within the definition of junkyard, and it is not permitted in this area. Now, they were able to have a conditional where they could have some display of motorcycles that were ready to sell, currently licensed and or titled. That doesn't mean that it's going to be licensed or titled after it's sold or when they have a buyer. It's the current status is licensed and or titled. Within testimony from the applicant themselves, from the appellant, significant amounts of those vehicles were never licensed and or titled. There were some, and they testified to that effect, but the majority was not. The majority was illegally stored outside in a junkyard on the property. Our position is just simply that they were operating an illegal junkyard, that there really is no ambiguity on this. The definition is clear. They themselves call the yard salvaged. However, even if it's determined that the BZA did grant the use of the salvage yard or junkyard, that granting would be in controversy with Genesee versus Beckham, 2006 Ohio 1174, in that the BZA never had the authority to grant something that they're not allowed to grant. No junkyards are permitted in this district. A junkyard is not a conditional use in the district. It's simply not permitted. And with that, Your Honors, I have nothing further.
So is the junkyard the unlicensed, untitled motorcycles plus the salvage material, metal, glass? Is that?
Correct. There is some storage of engines and batteries. They were very neatly stored in basically structures. They were outside, but they were neatly displayed. The majority of this, if you look at the aerials that are in the record, it just looks like a giant pile of metal bits. They just were not stored neatly. It was out in the open, and it was just piles and piles and piles of motorcycles, Sea-Doos, other recreational vehicles over a large expanse of the property.
Did the BZA utilize 431 in its decision, or 307, or neither?
I believe at the hearing, there were 13 counts, and there were a number of counts that were found not to be applicable. I am not positive if 307 was one of the ones that was found not to be applicable. I think that the kicker of those was the junkyard from the township's point of view, it was found to be a junkyard.
All right, questions? All right, thank you.
Thank you.
Mr. Ackner, I've got you at 3 minutes and 49 seconds left.
Right. Thank you. First of all, there are photographs of the collection, aerial photographs in the record, and if you look at them, you will see that the motorcycles they are organized in rows and rows. Some of them are very long rows. They are not in piles. I don't know where this comes from. Secondly, as far as the junkyard itself, again, our purpose, our objective was to find out what the specific facts were, and I asked the zoning inspector about that. And here's what the zoning inspector said, and these are highlights from provisions of the transcript of the hearing on page, on line 69. The junk that refers to the motorcycles. Page 179. Is it the rows and rows of motorcycles you claim are junk? Yes. Page 179. The motorcycles are motor vehicles. Page 535. And this is all testimony from the zoning inspector.
Well, you're not suggesting that if there was metal, unusable machineries, glass, salvage materials, that just because they didn't mention that wouldn't be considered in determining whether or not this was a junkyard or not?
Well,
Or are you?
what I'm suggesting, Your Honor, is I'm relying on what the zoning inspector testified to and what the Board of Zoning Appeals found. And what the Board of Zoning Appeals found was, yeah, it's a junkyard, that's what they said, and that there might, and that there was scrap metal on the property. But what the zoning inspector repeatedly stated, what she repeatedly stated was, I'm talking about the motorcycle collection. She said, it did not include gas tanks and parts that were stacked on shelves outside. It did not include engines and other parts. It did not include tires that were being used in the business. And so if among the motorcycles there may have been some stuff, that's okay, perhaps that's junk, but what she was calling the junkyard was the motorcycle part, the motorcycle collection. And our view is, we maintain that the motorcycle collection is specifically what they allowed, and it's what she specifically maintains was a junkyard. Now, I need to correct a couple of things that my friend on the other side said.
45 seconds to do it.
Okay. She pointed out that there's testimony in the record that half of these things, at least half, were not owned or licensed or titled. The fact is that Mr. Overholt testified that they owned all of the motorcycles on the property. The argument about 307E, the fact is it does not appear anywhere in the 2004 zoning resolution, and in 2006 this resolution was, quote, amended in its entirety to read as set forth in this zoning resolution update, adopted effective June 22nd, 2006, and as subsequently amended.
Were one
Unquote.
of the two citations that he was ultimately found guilty of, 30, guilty is
307E.
the right word, I'm sorry, was 307E one of them?
Yes.
Thank you.
Yes. And the other was the jury.
And with that, your time is up.
Thank you.
Thank you,
Your Honor.
Thank you both of you for your arguments this morning, and the court will take the matter under advisement, issue a decision in due course. The clerk of courts obviously will mail you each a copy of the decision once it's released, and the decisions are also posted on Supreme Court of Ohio's website, so you can check there. Thanks again to both of you.
Thank
for
you.
your
Thank
arguments.
you.